Good afternoon and welcome to today's panel on the topic of confronting racial injustice, featuring presentations from members of the clinical faculty about what the clinic has been doing to address racial injustice in this defining moment in our country's history. So this summer, spurred by the death of George Floyd as the latest in a long line of Black men, women, and children being shot and killed by the police, more than 15 million people marched in big cities and small towns around the world, with more than 500,000 people in 550 cities across the United States alone protesting on a single day. These protests reified a zeitgeist that led to many local, state, and federal actions against police brutality and racial injustice. They also created a space for a national discussion about shifting resources from policing into community-based networks and agencies that can provide mental health care, job training, counseling, and other holistic resources. Finally, and also really exciting development for those of us who've been working in the civil rights, social justice space for the last decade. These protests created a space for a long overdue national discussion of systemic racism. The Supreme Court has interpreted civil rights laws in a way that requires a litigant who is alleging race discrimination to offer specific, clear, explicit evidence of racial animus by a single identified actor whose main motivation was in fact racial animus. It's a really, really difficult test to meet, particularly these days when, for the most part, there is a great deal of social opprobrium attached to overtly expressing racially discriminatory views. So this focus presumes that by rooting out the isolated and egregious behavior of a few bad apples, and I know we've heard that language used repeatedly, particularly in the context of these police killings, bad apples, that we will eradicate race bias from our social systems. It also, this test that the Supreme Court has traditionally used, it also creates a presumption of racial innocence, right? That says that unless someone has done or said something glaringly, obviously, clearly racist, right? Like using a racial epithet, that person is not racist. The presumption is that they're not racist and that they're not motivated by racial animus. And though these examples of overtly racist behavior persist, thinking of racism with this impoverished understanding of intent underestimates how efficiently racism has basically sort of mutated and now operates in our society. And it allows racism and racist acts basically to hide in plain sight. It's pervasive and invisible like the air we breathe. Because the fact is, for most Black people, right, racism doesn't look like Bull Connor or like sicking dogs on Black children, or a declaration of segregation now, segregation today, segregation forever, right? That's not what it looks like anymore. Now what it looks like is, having to send your children to an under-resourced, heavily segregated public school that underprepares its students for college and for life, so that every day your child spends their day steeped in the soft bigotry of low expectations. Or it's a lack of access to supermarkets with affordable and healthy food. Or it's living hours away from a job that can sustain you and your family, because your city's public transportation system was originally conceived to keep communities segregated and was built in a way that targeted flourishing communities of color to benefit white communities. This is what racism looks like now, and it is the kind of racism that we all continue to tolerate. It's unlikely in these scenarios that we would ever be able to meet that test that I described earlier, that the Supreme Court's test of a single racist actor who authored the design of each of those things with clear evidence of racist intent. It's the problem, but this is the problem that we all continue to live with, to harken back to the Rockwell painting of Ruby Bridges desegregating her elementary school in Louisiana. So the fact is that now, whether a particular individual, in many ways, whether that a particular individual is racist is actually the wrong question. It's a red herring, because racism is phenomenological, right? So to paraphrase my favorite line from my favorite movie, the greatest trick that racism ever pulled was convincing our country that it no longer exists. So what we have now is we have social realities that clearly look like race discrimination in environmental policies, in policing, and in housing, but usually no single racist antagonist to hold responsible for them. And instead, we gaslight communities of color by denying that their lived experience, that in their lived experience, they are experiencing racism, and by telling them that their social problems are to a large degree their own fault. The distinguished presenters with us today will talk about what their clinics have been doing to confront systemic racism in different guises and racial injustice. Professor Nancy Loeb is the director of the Environmental Advocacy Center. Professor Sheila Bedi is the director of the Community Justice and Civil Rights Clinic. And Professor Sam Tenenbaum is the director of the Complex Civil Litigation and Investor Protection Center. Now, these are certainly not the only clinic faculty working on systemic racism or racial injustice issues, to be sure, but I'm thrilled that they are able to talk about their work with all of us this afternoon. As for format, each of the panelists will briefly discuss their work, and then I have a couple of questions that I'll pose to the panel, and hopefully we will have time at the end for questions from the audience. So once we reach the Q&A portion of the presentation, please feel free to pose a question in the chat. But first, we will turn to Professor Loeb, who will offer a discussion of her work.
Hi, everyone. I'm so pleased to be here. I'm so glad to see so many people joining us for this topic. I am a long-term environmentalist, but what that means to me has changed. And for many of the reasons that Robin was just talking about. So I grew up in a nice white suburb as a tree hugger and running around in green space with clean air and clean water to drink and loving nature. And as my attachment to the environment grew, I was generally unaware that the environment meant something so different to so many people. When she was speaking, Robin used the words, the air we breathe. But the air we breathe is not the same for everyone in that we. And it's because of that, because the air we breathe, the water we drink, the soils our kids get a chance to play in are so different for so many people that what the environment and environmental law means really shifted so dramatically in my focus. And that doesn't mean that issues of sustainability and climate and clean air and clean water broadly don't matter. But what it means is that we are living in a society today where we where life circumstances are so deeply permeated by racial injustice or environmental injustice. We often talk these days about environmental justice. In my view, the right way to think about it is environmental injustice, because that's what so many people are living with today. And so what I'd like to do is give you a little bit of background on Chicago and environmental racism in Chicago, and then talk about some of the work that our clinic is doing right now to try to fight this. So Chicago is a racist city historically. We built highways to segregate communities of color from white communities. Not only did that result in housing and living segregation, but it also resulted in horrors of environmental segregation, because everyone left on one side of that highway was left living in the remains of a century of industrial industry, unremediated steel plants, where homes were built right on top of it, where people live, where pollution continues to flow into the river, especially troubling where the homes continue to have lead pipes and the children are drinking water every day filled with lead that is a neurotoxin inhibiting their brain development. So intentional, legacy, sometimes just lack of care. The reality is that we are a city that with a history of environmental injustice, and that continues. What's the result of that? Well, today, chronic diseases like heart disease, respiratory disease, lung disease, COPD are the single biggest factor in Black residents of the city of Chicago having a 9-year less life expectancy than white residents. And a lower number, a lesser number of years of life expectancy for people in Latinx communities as well. So actual life and death effects, as well as developmental brain type effects on children resulting from these injustices. So I'm going to talk right now about one project we're working on right now for the Southeast Side Coalition to Ban Pet Coke, which got its name when it was fighting several story high piles of the residue of oil refining piled up right outside their homes and blowing through the air in their homes. And we've continued to work with them to fight the pet coke, to fight manganese, another neurotoxin in the air. And now we're fighting the move of a company called General Iron that is moving from Lincoln Park, and people who know Chicago know that that's a predominantly white, mostly affluent community, where General Iron is a large industrial metal crushing recycler that pollutes the air regularly, has explosions and fires, and the people of Lincoln Park have complained about it for decades. And when our new mayor came in, one of the first things she did in September 2019 was sign an agreement, a side agreement, directly with her general counsel doing it, with General Iron, moving them away from the $6 billion North Side Lincoln Yards development that also got more than $1 billion of city funds to develop in Lincoln Park. And where are they moving this? To the already overburdened southeast side of Chicago, where more than 50% of the population in the area is Latinx, 25% is Black, and the community has begged and pleaded not to add this additional pollution and environmental harm to the community. So we are very much engaged today. I don't know where my time is and I don't want to go over it, but this is our biggest fight today, is to try to protect this environmental community from this overt act of environmental racism by the city of Chicago. turn it back.
Thank you, Nancy. And now we'll hear for a few minutes from Professor Bedi.
Thank you, Robin. And Nancy is such a hard act to follow, but I'm gonna do my best, and I am going to take us back to where Robin started us with really grounding us in the remarkable, powerful uprisings that happened this summer. And as Robin said, all over the world, people took to the streets in the aftermath of George Floyd's death, raising up his name, raising up the name of Breonna Taylor, raising up the name of so many of the hundreds of other Black people who have been killed by police over the thousands of years that policing has, or the hundreds of years that policing has existed. And these uprisings were remarkable for their scale. They were remarkable for the ways in which they attracted people of all backgrounds. There were experienced activists. There were people who were just taking to the streets for the very first time. And they were lifting up a demand for police accountability, for justice, and also to defund the police. And here in Chicago, the Chicago for a very long time has been an epicenter of the fight for police accountability, in part because policing in Chicago has been so deeply racialized, so deeply violent for so long as the city itself has existed. And this summer, when people here in Chicago took to the streets, they were demanding an end to law enforcement brutality, an end to racism, an end to the violence that has been inherent in policing here. And the Chicago Police Department met those protests with violence, with brutality, with racism. What we saw was the Chicago Police Department demonstrating a propensity for acting in the exact same way that inspired these protests. And my clinic, my students, some of my other colleagues, both in the clinic and as well as around the city of Chicago, have been working for years to try to hold the Chicago Police Department accountable, to try to stop the abuse that we so often see when police interact with Black and brown folks, and to reimagine policing so that it is no longer functioning as a tool of social control. It's no longer functioning as a tool to reinforce racial hierarchies. So that's work that we've been doing for a very long time, and we had been engaged in trying to address issues with use of force and police accountability. And then this summer happened. And so many of the community organizers who we've been collaborating closely with were out on the streets. And so many of them were brutally beaten down by the Chicago Police Department. And what we saw during these protests was a real systemic use of police tactics that violate the Constitution. We saw, for example, the use of lethal head strikes, that this lethal force per CPD policy, per federal court order. We saw police officers using head strikes against people who were peacefully protesting. We saw really indiscriminate use of OC spray, of tear gas, pepper spray, which is problematic under any circumstances, particularly problematic in the midst of a pandemic, because the use of the OC spray causes people to cough. It can exacerbate any kind of lung condition. It also can cause the particles that deliver the virus to spread even further. So very problematic use of force. We saw police officers that were indiscriminately also taking people's property, that were using things like bikes and cameras as weapons against protesters. And we also heard language from police officers that really made their animus towards these protesters you couldn't mistake it. You could tell that one of the reasons why police officers were responding so violently is because these protesters, these people who had taken to the streets in support of the movement for Black lives, were particularly offensive to these officers. Officers saying things to protesters like, well, after beating them, if you don't like it, you should have stayed at home. Using all kinds of names and slurs So we had, in the context of our overall fight for police accountability, we had this evidence of the ways in which police are using their power and using violence in particular to try to quell this movement that has been gaining so much steam over the past few years. We tried to do some advocacy right after the initial protest this summer, and try to engage and try to inform the city of the patterns and practices that we had identified, to request that they stop. And instead, what we saw was the city, or the CPD, really doubling down. Each protest, as the protests began to roll out, in many ways, they were getting more and more violent. In some of the last protests we saw over the summer, we saw police engaging in the practice of kettling, which is where they issue an order for a protest to disperse, provide no route for dispersal, so protesters are trapped. So we have been documenting all of these violations, and my students and I interviewed well over 100 people, including activists who we had collaborated with closely over the years, as well as people who had just taken to the streets for the very first time this summer, and documented their stories, documented the narratives of police violence. And just yesterday, we filed a 60-person plaintiff lawsuit against the Chicago Police Department, seeking justice for those who were harmed by the Chicago police this summer, but also seeking to hold accountable the individual officers who harmed our clients, as well as seeking to hold accountable the city of Chicago itself. And the reason why that is important is because the kind of lawlessness and the violence that I just described, it's not new. It's not new to the city of Chicago. It's not new to policing, and it's not new to policing anywhere. And our complaint details some of the history of policing in Chicago, and goes back to 1919, where there were racial unrest in our city. And in the aftermath of that unrest, the city of Chicago pulled together a task force. And that task force issued a number of recommendations about policing and about race relations generally within the city. And the task force also documented the ways in which police during those uprisings failed to protect Black people, joined in white mobs that were delivering violence to Black folks who were on the streets. And then the report ended with a recommendation that, and I'm quoting here, that the Chicago Police Department needs to clean house. Chicago Police Department needs to clean house. So here we are, 100 years later, we've got another uprising in the same old Chicago Police Department that has failed to clean house. So we went quite deep into the story from 1919 to 1968, the Democratic Convention. CPD's response there was also quite violent. Some of you may have seen the movie that was just released about that violence. We also discussed some of the protests, some of the policing of protests during the Iraq War. So there's a real direct line that can be drawn from the founding of our city to the way in which police have been used as a repressive force, and particularly as a repressive force against Black people and against people who have advocated against the government and advocated for progressive change. So this lawsuit comes at a time when many of our clients are doing hard work at City Council, trying to advocate for the reallocation of resources that Robin described, trying to advocate for a reimagined public safety vision that would divest funds from policing and reinvest in the communities in Chicago that have been so under-resourced for so long. And that's one of the other things that was pointed out in the 1919 report, that one of the reasons why policing is such a deep problem in the city of Chicago is because of the ways in which Black communities were fundamentally underrepresented. So it is perhaps the optimist in me, but I remain hopeful that given the political imperative that exists right now, the strong organizing that is happening, that this might finally be the moment where we can make the 100-year recommendations to clean house in the Chicago Police Department and equalize investments in our Black communities real. So I'll stop there.
Thank you. Thank you, Professor Bedi. And now we will hear from Professor Tenenbaum.
Good afternoon, everyone. Racism in housing is pervasive and it manifests itself in many ways. Chicago is one of the, if not the most segregated city in the United States. One of the things we're looking at is what we can do about that. What I want to tell you about today is a case that we've been involved in over the last 2 years. It was the largest reverse mortgage fraud in history. It involved over 125 African-American homeowners on the west and south sides of Chicago who lost over $10 million in the equity in their homes. And these were people who did it right. They saved, they scrimped, they bought a home, they helped stabilize the neighborhood, and then found that all that they had built had been taken away from them. What I want to do first is show you a news clip about our case. That's a pretty good summary of what we've done. In it, my colleague and partner in the various work we've been doing on this situation, Juliet Sorensen, is going to be interviewed. And then I'll tell you a little bit more about it after the clip. And now I am going to test my technological abilities. Hopefully you can all see the screen now before I start the film. This was a news broadcast on ABC News.
Young lady came.
The story is all too familiar.
Can you hear it?
Young lady came out with a flyer, passing out flyers, asking people they needed work done on the house. You know, they had no money.
Yeah.
And just call the number and talk to Mark Diamond.
It's a scam Mark Diamond had been running for years, preying on elderly black homeowners with the promise of a free home repair program, but in reality, it's a reverse mortgage. In 2014, he convinced Kerwin Cockrell and his brother Bruce to sign up to get work done on their West Humboldt Park home. But
He started working on the house, putting a new roof on the house. And after that, you couldn't find him. Called me, he wouldn't show up.
years later, someone came knocking on Kerwin's door, telling him that his house was in foreclosure. The Cockrells, like dozens of other elderly African-American seniors living on the West Side, are close to or have lost their homes because of Diamond's schemes. In 2015, Illinois Attorney General won a civil suit ordering Diamond to pay restitution to dozens of his victims, which he never did. And in 2017, Diamond, along with 5 others, were hit with federal charges for fraudulently obtaining home loans in the names of at least 122 homeowners and pocketing millions in profits. Kerwin's brother Bruce died in May of 2016, leaving him, a veteran battling cancer while confined to a wheelchair, and Bruce's wife Eloise to figure out the legal mess.
They won't understand why people come here and just use people like this. You know, you think you get in the head and you fall back down.
Mark Diamond, he's like Teflon.
Attorney Juliet Sorensen, professor with Northwestern Law's Bluhm Legal Clinic, has taken on the Cockrells case for free. They lost an effort to have the foreclosure thrown out in trial court and on appeal, and was recently rebuffed by the Illinois Supreme Court, even though the court acknowledged mortgage fraud had taken place. But Sorensen says they're not giving up.
There are a variety of ways to skin a cat as we seek justice for our clients.
Reverend Robin Hood, executive director of the Illinois Anti-Foreclosure and Eviction Coalition, uncovered Diamond's scam.
It is evident after 5 years. These people were a criminal enterprise. So just stop even thinking about putting people out of their homes. They had to deal with this criminal enterprise that they face with. That needs to stop right now.
It's our home. You know, they want my building for nothing.
You say no.
No,
You don't fight.
no fight, because I can help it. They ain't getting this one.
Diamond, the criminal case is ongoing. We got involved when the U.S. Attorney's Office realized somebody's got to straighten out the problems related to 125 homeowners who have fraudulent mortgages on their property. We've been involved in a variety of activities that take on a whole range. The reason I wanted to show the clip is there's a human face to our clients. They're people, they're human beings, and they were the ones affected by this fraud. We got involved in the case 2 days before the Cockrells were going to be evicted. That was in 2019. They're still in the house. We fought that case up to the Supreme Court. We're getting ready to file another lawsuit to undo what happened, because actually a fraud on the court occurred while they were in the eviction. They lied in their court papers in order to get the foreclosure. There's a bad statute in Illinois that prevented us from raising these defenses on the trial court, but they won't prevent us from filing a new lawsuit that we hope will ultimately work to provide relief. We've been involved in a number of foreclosure actions, raising defenses and fighting it on in the trenches, one-on-one. It's involved all the students in my clinic. Additionally, one of the main lenders filed a $10 billion bankruptcy in New York. Our clinic was named to the Consumer Creditors Committee. We had to fight the debtor. The debtor wanted to use the bankruptcy to eliminate the ability of people who've been defrauded from raising those frauds as a defense to foreclosures. We were successful. We got a 125-page precedent-setting decision that said you can't use the bankruptcy process to take away rights that consumers have. We also, after we got that ruling, were able to get $10 million in a settlement fund to help compensate people who had already lost their homes. And this was a nationwide problem with these lenders. One of the things we did, and now I'm going to try to put my technology to work. I'm going to share my screen again, is this, and I'll make this bigger so everybody can see it. Member of the community volunteered his space, and we spent an entire weekend with my students doing one-on-one interviews with all of the clients we're representing in these cases, gathering facts, meeting the people, and really developing a relationship with their clients. And that's something all of our clinics do. I don't want you to think we're unique in that regard. Just some of the things we've done. And now I'm going to minimize that and put up another PowerPoint. Hopefully you can all see this one too, and I'll make that bigger. We've been involved really in what I call holistic representation. And this is also something that we at the clinic can do. Can you all see that PowerPoint? All right. You know, we've got defensive foreclosures, involvement in bankruptcies, dealing with the federal criminal system, dealing with the Illinois Attorney General, dealing with various city agencies, housing departments, taxation. We've helped them with estate planning. It really has been an all-in type of representation to help these people, and community outreach, where we've gone out and actually spoken to groups of senior citizens to help try to prevent these kinds of frauds from happening. What I want to do to sum up, I think I'm pretty close to being on time. Robin sort of gave me a look. That's all right. What I want to do is at the end of every semester, our students do journals where they talk about their experience. And I've gotten permission from one of my students to read excerpts from his journal, because I think this summarizes the experience that clinical students get. Here's what he wrote. My time in the clinic has been an absolute encouragement. I have seen how law can change someone's life for the better and do justice to those who have wronged others. The clinic has been such a blessing because it allowed me to learn while helping others. One of the clients I got to work with was an African-American 65-year-old woman who had lived in her current residence for 30 years. Her grandson, who's disabled, lives with her. Diamond came to her home and showed her pictures of model homes, saying he would make her home look just like the photos. The cost of repairs, Diamond claimed, would be $2,250. He told her she needed to sign some paperwork. She didn't know what she was signing, and she signed a mortgage for $186,000. Diamond kept the mortgage loan proceeds, failed to do any of the repairs, didn't pay back the loan, nor did he refund any money to her. She couldn't afford the mortgage payments, received a foreclosure notice, and was forced to file bankruptcy. And we've been working, and then he goes on to say, hopefully through the clinic's efforts, these victims will be compensated in some way to help make up for the undue suffering they've endured. And that's what we're working on. He then says, I am not Jewish, but I always love this quote from the Talmud. Whoever saves a life, it is considered as if he has saved the world. By many standards, helping just one or two people isn't that substantial, but undoubtedly means a great deal to those individuals receiving the help. That is what matters most in the grand scheme of things. The clinic does good things, and anyone who helps to help those in need should take a clinic class. It will give them a refreshing perspective on how impactful a law degree can be to those in need. Let me just say that on behalf of my colleagues and myself, aside from the questioning we're going to do here, if you have other questions or want to find out more about our work, feel free to contact us. We'll be more than happy to work with you and talk with you. So now I am going to turn this. I also want to say, this is why I teach, to hear that. So I want to turn this back over to Robin so she can deal with the questions.
Thank you. Thanks, Sam. I'll pose a question to the panel. And my first question will be, how are or were your clients experiencing these unfairnesses, right? Like, did they label them racist, or did you? And was it important to your clients to communicate the fact that they, to communicate the racial discrimination against them to the court? And how, if at all, does your legal claim communicate your client's experience of racism? We can, Nancy, and then Sheila, and then Sam. We'll keep the same order.
Sorry, slow on the unmute button. We did not, as lawyers, we did not initiate the claim of racism. This is something that the community feels and has been feeling for a long time as more and more dirty industry is moved from more affluent white neighborhoods into this community of color. It doesn't take a lot for anyone, but especially people living it, to figure out what's happening here. And one of the things that we did recently because of this, and this goes back to what I was saying before about the broad ways that environmental policy is linked to many of the policies of the city that perpetuate and entrench segregation and racism. And at the end of the summer, beginning of the fall, we filed an unusual environmental type complaint, but it was a complaint with HUD, going, as Sheila described that they did, going through the long history of environmental and land use policies in the city of Chicago, beginning with building highways, but also creating industrial corridors, almost all of which are in communities of color in the city, and moving industry from the north side to the southeast and the west sides of the city in what have been labeled receiving zones. And so we filed a civil rights complaint with HUD, complaining that, and this is not a lawsuit, it is a complaint with HUD, which is now investigating the claims, that these land use and environmental policies, which ostensibly are unrelated to housing and racial policies, are in fact very much another element of the segregation and the entrenchment of the segregation in the city.
So in terms of my my clients, I mean, many of them are longtime community activists who have a racial analysis and have a power analysis, and sort of recognize that policing is inherently racialized, and that one of the reasons why protesters this summer were targeted with such violence, and some of this is in the words in the social media accounts of Chicago police officers, is because they were protesting for Black lives. I think that is an analysis that is you know, as Nancy described, just sort of inherent in the experience. When you are a person of color, you sort of know, right, how much of this is coming, how much of what you are receiving is coming as a result of the racism that is, again, as Nancy said, the air we breathe. You know, inherent in every institution. Despite that fact, and I think this is the core of Robin's question, and really gets back to her framing, it is so difficult for us to bring those challenges of the racism that we see so clearly in court, because of the high burdens that we have for proving for proving discrimination and for proving up those claims. We do have an equal protection claim that argues that the protests in support of the movement for Black lives were policed in a far different manner than, let's say, Wrigleyville is after a Cubs game, and making clear that some of the justifications for the use of force cannot be justified given the disparate policing response that we see. So the challenge that we have as civil rights lawyers is to take our clients' lived experience and to try to put it in a framework of the law that just isn't fulsome enough to fully reflect and challenge the realities of race in this country.
Look, in Chicago, housing has been forever a racial problem. Redlining, forcing communities to live in a particular area. And one of the things, frankly, we're looking at is the utilization of Chicago's set-aside program that they use, that a certain percentage of any new development is supposed to have affordable housing. What do? They allow developers to buy out, take the money, use it for public housing. Where do they build the public housing? In the segregated neighborhood, as opposed to actually having mixed communities. But, Reverend Hood is great. He's a community activist. He realized that there was a systemic problem, but our clients are not community organizers or advocates. They're just people who want to live in peace in their homes. And now they're facing losing their homes. And their homes really are kind of nice. It's something many of us folks maybe don't have anymore. They have 2, 3, even 4 generations living in their buildings that they own, in a 2-flat or a 3-flat. And it's really nice. The family's all together, and they, their plan was to pass it on to their kids and their grandkids. And then that plan got blown up as a result of the fraud. There's no question that companies and fraudsters target the African-American community. That was clearly the case here. In fact, there were African Americans who worked with Mark Diamond, who helped sign up these people to these mortgages, which is also a problem. But it's clear they're targeted because of who they are, what their education level is, economic level, and all of those factors have come into play in the cases we're working on. Throw it back to you, Robin.
Thank you. Thank you to all three of you. Now I'll pose another question, which is, all of you are representing groups of people, right? It's not an individual litigant against an individual. So I'm hoping that you would all please talk about how effective or ineffective the law can be when it comes to vindicating the rights of groups of people who have faced discrimination. What are the limitations? What are the tools? And even what would you change if you could? We'll do the same order. Nancy, Sheila, Sam.
So yes, we're working with the Southeast Side Coalition to ban pet coke, and very closely tied as well with the Southeast Side Environmental Task Force. And what we're seeing right now is a rise, a wonderful rise of Chicago environmental network groups. There is a Chicago Environmental Network, and communities are now standing up and fighting for themselves. And what that does in the legal context that I think is so important, and it's something Sheila mentioned, it gives voice to the people whose lives are affected. And our role is shifting more into a more legal role. And in the past, when community groups had less experience, we were also more in a role of pushing the public advocacy as well, or leading the public advocacy. And I think it is one of the really monumental and terrific changes that community groups have become so well organized, at least in the environmental area, that they are taking the lead now and expressing what the problem is, because it should be their voice, not mine. And what I and the students working in the clinic should be doing is providing the legal support and strategy support and advocacy tools to back them up, rather than being the people out in front.
So we similarly to Nancy, represent a number of groups in two different ways. We do some class action work where we've gone to the courts and asked for a class that has been similarly situated to be established so that we can try to change policy. In most of those cases are relation to Department of Corrections. And those cases often have their own challenges in terms of who is a representative plaintiff, what does it mean to act in the best interest of the class. We really can dig into so many issues of both civil procedure and ethics and institutional change. We also represent community-based groups and community-based groups that some of which are old or have been around for a while, well-established organizations like the NAACP have a very clear hierarchy. You know where you need to go if you need to get an answer to a question. And then there are the younger activists that don't believe in having that kind of organizational hierarchy and believe in just having a flat organizational approach. And every decision is made through consensus-based decision-making practices. And that each model of organizations has its own challenges when you are a lawyer who's trying to make a decision in a fast-paced litigation process, but also some real benefits as well. And one of the things that I think is really important about doing the kind of work where lawyers are partnering with non-lawyers who are in the community and who are community leaders, is that it really builds the capacity of communities to engage with for legal assistance. It really helps community groups understand, what does it mean to have a legal strategy? How can a legal strategy bolster a community organizing, a policy strategy? How can the legal process sort of both help shed light on the truth of what people are experiencing, and also function to hold accountable government actors, while also allowing the hard work of organizing and doing the kind of direct actions to continue. So I think those partnerships are really powerful, and they can certainly present challenges, but they're really important things for, I think, our students to be exposed to, and to be recognizing that the client counseling piece of this and the client counseling piece of our work is really foundational, and is really the piece that everything else should center.
Our cases presented unique challenges. In the Cockrell case, the problem was there's a statute that says that if you purchase at a foreclosure sale, you get a clean title and nobody can raise any defenses to that title. We challenged whether a lender who does a credit bid at a sale, who has a fraudulent mortgage that they're seeking to enforce, and who has enforced it through fraudulent means, could challenge that statute. And we took it all the way up to the Illinois Supreme Court, and what the appellate court ruled, that was the Supreme Court didn't take the case. What the appellate court ruled was, we can't change the statute. You have to have the legislature do that. So we're going to try to do that. So that leaves us with filing an action for abuse of process and malicious prosecution based on what was done to the Cockrells. With respect to the other clients, we were similarly handcuffed because we had a number of different lenders and relatively few to each lender. I couldn't file one class action on behalf of everybody. If I'd had one lender who made all 125 loans, that would have been easy. Could file a class action, seek to set aside all the mortgages all at once. So we had to develop a strategy, which we have, to try to challenge that. And what we're going to do is, we are going to file, I think, around 40 counts, declaratory judgment complaint, in one complaint, suing all the different lenders on behalf of all of our clients. Now, part of the problem is there are a number of people who despite, believe me, door-to-door knocking, community outreach, trying to get clients to come in, sign up, are either embarrassed or don't want to, or for whatever reason. I mean, many, I'm sure, are just, folks know this. People in the African-American community are scared of the legal process. Some of the people thought when our students went out to try to meet with them and interview them, that they were actually still working. They were working for Mark Diamond. So we faced that resistance, that if I had the ability to file a class action, I wouldn't need them all to come forward. I could handle all the cases for them. But for all those who we have been able to come forward, we're going to file this massive complaint that we just reviewed one of our final drafts of, to try to get all these mortgages set aside. But that is some of the limits when you have a number of individuals who have been harmed, as opposed to the traditional class. Back to you, Robin.
Thanks, Sam. So it is, we have only 3 minutes left. And so I am reluctant to get into audience questions because I don't want to hold people late. And I'm sorry about that, but we are, as different panelists have said, we are available. Please feel free to reach out and talk with us about anything that you've heard in this panel, or if you want to hear more about the students' experiences, we're we're home, right? So, but in the meantime, thank you so much to everyone for taking the time to participate in this conversation, which I hope you experienced the same way I did, which was as critically important, but also inspiring. And I don't know about you, but I can use all the inspiration I can get these days. And I'm fortunate enough to work with people who constantly inspire me. And so I hope that you had a chance to experience that as well. Because while the events of this summer absolutely spurred a long overdue national conversation, we know that real change will come through diligent and focused action to confront systemic racism and racial injustice every single day. Under the guidance of faculty like these incredibly dedicated and creative folks, clinic students hopefully learn to see, to recognize systemic racism and apply and figure out the way to apply their skills to address these real life problems. Because even though the forms that racism seems to take, it seems to mutate. It's a legal theory called status regime modernization. It seems to mutate over decades. Hopefully the form of our resistance can do that as well. I also want to ask you, invite you to join us for a second conversation in our Giving Tuesday series on December 1st at 3:30 p.m. To learn more about the clinic's work with respect to, in terms of responding to the COVID-19 crisis this summer and continuing into the fall. Please consider making a gift to support the clinic as part of our Cats Give Back Giving Tuesday campaign. Your support will help us unlock actually a $50,000 gift from Meredith Bluhm Wolf, class of '95, and provide resources for us to continue this work for free, which is a critical part of our mission. So thank you so much to everybody for spending some time with us this afternoon, and have a good weekend and a good holiday.